for the claimant. Appearing with me is my learned friend, Ijoma Injemanze. Most grateful, my Lord.
Appearance of the defendant.
With profound respect, my Lord. My name is Laji Arikewujo. I announce my appearance for the defendant.
In giving the judgment, I shall simply read the claim and go to the decision portion. I hope you can hear me.
Very well, my Lord.
Judgment. The claimant filed this complaint against the defendant, together with the statement of facts and the other accompanying processes on the 22nd of April 2015 by an amended complaint filed on the 25th of November 2019. The claimant is seeking the following reliefs against the defendant. A. An order declaring as unlawful the termination through dismissal by the defendant of the claimant's employment. B. An order declaring as illegal the unauthorized withdrawals by the defendant of monies contained in the bank account of the claimant, his wife, Mrs. Blessing Romeo Menogo, and his brother, Mr. Johnny Chukwunedu Menogo. C. An order declaring as illegal the unauthorized and unwarranted sale of the claimant's UBA shares by the defendant. D. An order for restoration of all the monies converted by the defendant from the current account number 100175334 of the claimant in the sum of 4,500,000 naira and pre-judgment interest thereon at the Central Bank of Nigeria maximum monetary policy interest rate. E. An order for the restoration of all the monies converted by the defendant from savings account number 094 14990102153 of the claimant in the sum of 100,000 naira and pre-judgment interest thereon at the CBN maximum monetary policy interest rate. F. An order for the restoration of all the monies converted by the defendant from the account of the claimant's wife, Blessing Romeo Omenogo, in the sum of 320,000 naira and pre-judgment interest thereon at the CBN maximum monetary policy interest rate. G. An order for the restoration of all the monies converted by the defendant from the account number 0194800641152 of the claimant's brother, Mr. Chukwunedu Johnny Omenogo, in the sum of 200,000 naira and pre-judgment interest thereon at the Central Bank of Nigeria maximum monetary policy interest rate. H. An order that the defendant buy back for the claimant all UBA shares in the quantity of 100,000 units of shares unilaterally sold by the defendant without the consent of the claimant. I. An order that the defendant repay the claimant all the dividends earned on the said shares from 2006 until satisfaction of the judgment of this honorable court. J. An order that the defendant shall make a full-page letter of apology in 2 national daily newspapers exhibiting the claimant's picture and apologizing for the damage done to his name, character, and career by the false accusation of fraud leveled against him, and stating thereon that the Central Bank of Nigeria, the Bankers Committee, the Chartered Institute of Bankers of Nigeria, and the Securities and Exchange Commission should take note. K. An order that the defendant shall
À.
Sorry, gentlemen, can you hear me? Can you hear me?
Yes, my lord. We can hear you, my lord.
Okay.
Yes, my lord, we can hear you, my lord.
Sorry about that. We had the light went out and everything went off. Sorry about that. Okay, I think I was on relief K. Yes. An order that the defendant shall withdraw the letter of dismissal issued to the claimant dated October 12, 2006. L, an order that the defendant calculates and pays the claimant total sum of 80 million naira being his salaries, including the deductions usually made by the bank payment into the claimant's pension account with ARM pension managers, and emoluments from the date of his arrest by the EFCC upon the petition of the bank until the date of the filing of the suit. M, an order that the defendant pays the claimant salaries reflecting the promotions that he would have received had his employment not been illegally and unlawfully terminated. N, an order that of the letter of dismissal that the defendant and accepts letter of resignation from the claimant. And O, an order that the defendants pay the claimant his attorney's fees and costs in the sum of 25 million naira. P, an order that the defendant takes full and financial responsibility for the removal from the internet of more than 5,000 naira negative. C, general damages in the sum of 350 million naira as compensation for all the claimants suffered. And monumental harm or wrongful dismissal through termination of his employment. The defendant statement of defense on the 4th of December 2019 and accompanying processes. The claimant had amended statement of defense on the 25th of August 2017. I shall go straight to the decision portion. I have processes filed, written submissions, and authorities cited by the parties. I will bring the preliminary. Learned counsel to the claimant applied to abandon in PF. These claims Learned counsel to the defendant has argued in paragraph 9.00 of the final address that this court lacks jurisdiction to entertain claims J and Q. The defendant filed a notice of preliminary jurisdiction of this court to entertain this suit and the said claim. In a considered ruling dated April 26, 2006, the notice of preliminary objection was dismissed and the court assumed jurisdiction. The defendant did not file an appeal against the ruling. By raising this issue again in final address, the defendant is asking this court to sit on appeal over its own decision. The court is conscious of the issue and cannot appeal over its decision. It is the cases of International Estate versus Francis, Augustine, Asukwo, Afikpo. It is the law that when an employment that the terms of his employment contract have been breached. The employee has not only to place before the court the terms and conditions of his or her employment, but the manner in which it was breached by the employer. Idoni Boye Obo versus NNPC. As to any legal right or liability dependent on the existence of facts which we assert must also be evidence. It is also are decided on the balance of probabilities, on the preponderance of evidence, the burden of from side to side, and the onus of producing further evidence on the person who will fail if such evidence is not adduced. Osuji versus the issues that are as follows. A, is the defendant committed to check payment recognition and then proceeds to sue him? B, was there a reasonable cause that led to the prosecution of the claimant? C, as the claimant 100,000 units of the defendant's shares? D, is the claimant taken from his account by the defendant? E, is the claimant entitled to general damages? There is no dispute between the parties that the defunct Standard Trust Bank employed the claimant on June 21. After the met defendant on August 1, 2005, the defendant offered the claimant employment on August 11, 2005, subject to its internal regulations as set out in its staff handbook, circulars, and memorandum. See Exhibit 15, C15. Both parties are in agreement, as distilled from the pleadings and evidence, that the claimant was regarded as one of the defendant's few super staff, having scored 101.40% in his appraisal, Exhibit C8, and he enjoyed several promotions. From the evidence before the court, the defendant approved the claimant's annual leave to commence on 16 June 2006 and to resume back to duty on July 19, 2006. He traveled to the UK on the 16th of June 2006 for his annual vacation. The defendant wrote a petition dated June 21, 2006 against the claimant to the Economic and Financial Crimes Commission, alleging fraudulent overdrafts by a customer with the connivance of the claimant. The report by the audit group of the defendant, dated June 22, 2006, was also sent to the EFCC. The claimant's evidence is that he became aware of the allegations of fraud against him while he was on leave in the UK and decided to tender his resignation because he felt the defendant had lost confidence in him, as the defendant did not contact him on the issue. He resigned from the defendant by his email dated July 19, 2006, Exhibit REO2. The defendant refused to accept his resignation by its letter dated 21st July 2006 on the grounds that he had a disciplinary matter and requested that he appear before the head office mail Exhibit D4 on 31st July. He sent a formal query as he did not know what his offense was. He was informed that he could not be queried by email and must report to the office by 30th August 2006 for questioning, failing which a decision will be taken in his absence, Exhibit D3. Now, fair hearing simply means hear the other side. The Supreme Court in the case of Imonike versus Unity Bank PLC has held that where an employer accuses an employee of misconduct, by way of a query, and the employee answers the query before the employer takes a decision on the employee's appointment that satisfies the requirements of fair hearing. The claimant, having tendered his resignation, did not report to the office. A letter dated October 12, 2006 came with effect from September 29, 2006. I find that the defendants did not. Can we please mute ourselves, please? I find that the defendants did not inform the claimant of the allegations against him before its petition to the EFCC and the claimant's resignation. Neither did the defendants give him the opportunity to defend himself on the allegations by a query. The position of the law is that a notice of resignation becomes effective and valid the moment it is received by the person or authority it is addressed to. This is because there is absolute power to resign and no discretion to refuse to accept. And it is not necessary for the person to whom the notice of resignation is addressed to reply that the resignation has been accepted. See Yesufu versus Governor of Edo State, Benson versus Onitiri. The defendant is not permitted to refuse to accept the claimant's resignation. In WAEC versus Oshonobo, the court held that a notice of resignation is effective, not from the date of the letter or from the date of acceptance, but from the date on which the letter was received by the employer or his agent. And that tendering of a letter of resignation by an employee carries with it the right to leave the service automatically without any benefits, subject to the employee paying any of his indebtedness, subject to the employee paying off his indebtedness, if any, to his employer. The claimant's notice of resignation became effective the moment it was received by the defendant on July 19, 2006. In view of the position of the law, it is therefore needless to make a specific order granting relief N, a relief expressly granted by law to the claimant. I hold that the claimant's resignation from the defendant's employment was effective and valid on the 19th of July, 2006. In the circumstances, the claims for outstanding salaries and emoluments in reliefs L and M are refused as the claimant ceased to be an employee of the defendant with effect from 19th July 2006. Now, I must state that the fact of a pending disciplinary matter is immaterial to the validity of resignation. In Ine Monday Ngbeti versus Unity Bank PLC, a clause in the employee handbook which provided inter alia that management reserves the right to reject a notice of resignation or payment in lieu from an employee if it is seen as a strategy to cover up a fraud or misconduct to avoid disciplinary action was not only struck down by this court, but it was held to approximate to forced labor, contrary to Section 34(1)(c) of the Constitution and Section 73(1) of the Labor Act. As such, the provision was illegal and unconstitutional. In arriving at this decision, the court placed reliance on the ILO Convention concerning forced or compulsory labor, 1930, number 29, otherwise called the Forced Labor Convention, ratified by Nigeria and in force. The claimant, having effectively resigned his employment with the defendant on 19th July 2006, was no longer its employee and therefore not subject to any disciplinary proceedings thereafter. Consequently, the defendants, who no longer had any authority or control over the claimant, could not issue to the claimant an invitation to a disciplinary hearing to hold on 12th October 2006 in respect of an employment that had ceased to exist. Furthermore, the dismissal letter as admitted by DW was retroactive, and it stated that there is no provision for retroactive dismissal in the defendant. I find the defendant's letter dated October 12, 2006, dismissing the claimant with effect from September 29, 2006, from an employment that was no longer in existence, to be made in bad faith, as the defendant is well aware that a summary dismissal carries with it a stigma. The letter is pointless and a futile exercise. See Jumbo versus PAFMB. I hold that the letter of dismissal dated 12th October 2006 is wrongful. The defendant is ordered to withdraw the letter of dismissal. The claimant has alleged that the defendant made a false accusation of fraud against him, acted mala fide and maliciously instigated his prosecution. The evidence of DW is that a fraud was detected on 14th June 2006, and there was an ongoing investigation. The claimant, who had not yet proceeded on his annual leave, was not queried or questioned before he proceeded on his approved annual leave on the 16th of June 2006. The defendant wrote a petition to the EFCC alleging a fraudulent overdraft withdrawal of 9.2 million by its customer, Mr. Ine Francis, who was allegedly assisted by the claimant. There's no question that the defendant, by its petition, set in motion the criminal prosecution of its employee without first informing him of the allegations against him and an opportunity to defend himself ongoing. I find from the evidence that the claimant had not yet proceeded on leave when this investigation commenced. The claimant was, by this action of the defendant, denied his right to an administrative query and a fair hearing at the workplace before the matter was escalated. The employer's duty, where a panel of inquiry has made out a case against an employee, has been succinctly stated by the Supreme Court Training Center, per Namaka Agu JSC, and I quote, up its mind. Sorry, yes. Can you hear me, please? Can you hear me?
We can, my lord.
So, yes. Okay. But once the panel has concluded its inquiry and makes up its mind that any points had been prima facie made out which point to the fault of any person, the employer must first inform such an employee of the points in the case against him and give him the opportunity to refute, explain or contradict them, or otherwise exculpate himself by making any representations or defense thereto, before the employer can lawfully use those for dispensing with his services. Where those points amount to crime, the case must be reported to the police for investigation and possible prosecution. The claimant has not made a specific claim in respect of this issue that he canvassed in address, and I so note. The next question is whether there was reasonable cause to prosecute the claimant. The evidence of DW in paragraph paragraph 6 of his deposition is that, and I quote, at the material time, the defendant petitioned the EFCC and the subsequent prosecution necessitating the petition and the actions that followed from the EFCC were as a result of the finding from their investigation, end of quote. The decision of the Court of Appeal in the claimant's appeal, suit number L/560/2012, Romeo Omenego versus the Federal Republic of Nigeria, delivered on 28 February 2024, 3 to 25, is reproduced. I think appellant's grounds 3 deserves some consideration. While it is settled that the law does not insist that there must be no contradiction in the evidence of a witness, I'm of the view that the contradiction must be material to the extent that they cast some doubt on the mind of the court. The appellant brought out genuine conflicting evidence between the letter exhibit P8 to EFCC, extrajudicial statement of the witness, and testimony in court. Where an extrajudicial statement of a witness is in sharp contrast with the vivo vox evidence in court, both are rendered valueless and unusable by the court. The testimony shall be treated as unreliable, and the statement is not to be regarded as evidence the court can rely upon to convict. See Egbonome versus the state, Nwankwo and the state, Akpan versus the state. The appellant in this appeal pointed out conflict in the evidence of the prosecution by the appellant. The law frowns at or witnesses called by one party giving evidence that are diametrically opposed to one another on material points. See Olayinka versus the state, Akpa versus the state, AK versus the state, versus the state. I hold the view that the contradiction pointed out in the issues submitted by the appellant for determination are not trivial. Having resolved issues 1, 3, 4, and 5 in favor of the appellant, I think the necessity to determine issue 2 and 6 is obviated as resolving the issues may be academic. Resolution of issues 1, 3, 4, 5 has effectively determined the appeal. Appellant's appeal is hereby held to be meritorious and succeeds. Judgment of the court below delivered on 15 February 2012 by Oyewole J. of the High Court of Lagos State is hereby set aside. Appellant is discharged and acquitted, and the order of restitution made against the appellant is also set aside. The judgment of the Court of Appeal is unanimous and speaks for itself. The claimant was discharged and acquitted as a result of the matter to the EFCC, extrajudicial statement, attempted appeal to the Supreme Court by the defendants through the EFCC in suit number SC 312/2017, Federal Republic of Nigeria versus Romeo Omenego, was refused and dismissed by the Supreme Court on November 30, 2017. Perhaps if the defendant had queried the claimant and heard him while carrying out its own internal investigation, particularly after the claimant had so demanded for a query to be issued to him to enable him respond, his prosecution would have been needless, as the material contradictions pointed out by the Court of Appeal would have been apparent. The claimant has complained that the defendant unilaterally and without his consent sold his 100,000 units of UBA shares, which was worth 6 million as at the date of the sale on 20th of October. The evidence shows that the defendant credited the claimant's account with the sum of 1,094,478 naira for the sale and repurchase of the shares. The claimant's evidence is that he, along with other staff, signed sale agreement forms for the defendant to sell the shares at the market rates and credit the account of the member of staff that leaves its employment This therefore means that the defendant sold the shares with the consent of the claimant, who had already disengaged. As evidence for the assertion that the shares were worth 6 million, the claimant has put in evidence the defendant's annual reports and accounts, financial statements for years 2006 to 2014, Exhibit C19, and stated that the value can be calculated from the share prices and dividends declared by the defendant. Now, this is in the realm of special damages that must be specially pleaded, particularized, and strictly proved. In other words, the claimant is to give necessary particulars in the pleadings, adduce credible evidence, and satisfy the court as to how the value and sum claimed was quantified, because special damages are rewarded for actual or exact losses suffered. See Onyora versus Ben Onyora. There are no particulars in the pleadings in respect of the value of each share. The claimant failed to link the exhibits to the value of the shares in October 2006 and has simply dumped documents on the courts without the contents being examined in open courts. It is not the duty of the courts to embark on a voyage. The claimant has failed to prove that the value of the shares is 6 million. Therefore, claims C, H, and I therefore fail. The claimant has complained that the defendant unlawfully converted monies from his current account and his savings account. On June 26, 2006, the claimant had the sum of 418 naira 38 kobo as the balance in his current account. In the dismissal letter, the defendant stated that the claimant's indebtedness is 916,116 naira 16 kobo, and that the value representing the proportion of the fully paid up staff shares in the trust scheme will be credited to his account. The claimant's shares was sold for 1,094,478 naira. I find that this was enough to pay off the claimant's indebtedness of 916,116 naira 16 kobo, leaving a balance of 178,361 naira 84 kobo. On November 9, 2007, the claimant's current totaling 4,131,094 naira. And this brought his balance to 4,485,492 naira 72 kobo. The claimant's bank statements reveal that the defendant debited his account every month for loan recovery in the sum of 20,496 naira 7 kobo from 25th July 2006 after his resignation until the 25th of May 2010. And he had a credit balance of 3,890 naira 490 naira 98 kobo. On the 18th of March 2014, the defendant debited the account in this sum, describing it as outstanding recovery from account and leaving a zero balance after it had become aware of the decision of the Court of Appeal. The evidence of DW is that the claimant's account was debited in repayment of his personal indebtedness of 916 naira 916,116 naira 16 kobo. GW admitted that the monies deducted from the claimant's account were for fraud recovery, for which the claimant was discharged and acquitted, and that the defendant made an attempt to appeal to the Supreme Court through the EFCC, but the appeal failed. I find that the sum of 4,485,492 naira is the sum due to the claimants, the order for restitution by the High Court having been set aside by the Court of Appeal. The claimant has asked for prejudgment interest, but there are no pleadings in this regard, and therefore this cannot be granted. The defendant is ordered to pay the sum of 492 naira to the claimant with interest at the rate of 20% per annum until the sum is fully paid up. There's no proof before me that the defendant converted the sum of 100,000 naira from the claimant's savings account. Therefore, relief E is refused. The claimant is seeking an order that the defendant takes the full financial responsibility for the removal of the internet from the internet of more than 5,000 negative publications on him. There are no pleadings in this regard, and it is therefore deemed abandoned by the claimant. The claimant also seeks an order for the defendant to pay his attorney's fees. There is no evidence of counsel's fees or bill of charges. Furthermore, the position of the law is that a claim for counsel's fees, which does not form part of the claimant's course of action, is not one that can be granted. See eBay versus Bonum, see Michael versus Access Bank. And it is also unethical for a litigant to pass the burden of his legal fees to his opponent. See Guinness Nigeria PLC versus Muke. The claimant has made a claim for general damages as compensation for the psychological, emotional, and physical trauma he suffered and his incarceration for 10 years. I find that the claimant was arrested on 19th October 2006 by the EFCC on the defendant's petition and detained without bail for 4 months before he was arraigned. He was refused bail by the High Court, was remanded at Kirikiri Medium Prisons till the conclusion of his trial, served a 10-year sentence, and prosecuted his appeal to the Court of Appeal from Kirikiri Medium Prisons. He was discharged from prison on 19th of October 2013, and the judgment of the Court of Appeal was delivered on the 28th of February 2014. Mr. Fola Afawari, in his article, The Prosecutor in Public Prosecutions, published by Lagos State Ministry of Justice Law Review Series, January 1, 2000, at paragraph 21, referred to Scott Turo in his book, Presumed Innocent, that, and I quote, "You must imagine how it would feel to be pinned down by a criminal indictment, held at the focus of scrutiny, ardently denounced society, knowing that the most ordinary privileged life, common trust, permanent respect, and even liberty are things at risk and which you might never retrieve. In the care and caution required in the exercise of and effect of the powers to order prosecution." End of quote. This is because there can be little remedy where there has been judicial intervention. There has been judicial intervention after the defendant reported its suspicions to the EFCC. The Supreme Court in Isheno versus Julius Berger has held that the arrest, detention, and subsequent prosecution of the appellant by the police could not form the basis for an action for damages for false imprisonment or malicious prosecution or defamation of character against the respondent. Under the principle of stare decisis, this court is bound to follow the decision in Isheno versus Julius Berger Supra. Consequently, the reliefs number J and Q, seeking an apology and general damages, must fail. They are hereby refused. On the whole, the claimant has succeeded in claims A, claim D, claim K, and claim N. I hereby declare and make the following orders. 1, I declare the letter of dismissal dated 12th October 2006 wrongful. 2, the defendant is ordered to withdraw the letter of dismissal dated 12th October 2006 within
14 days. 3, the defendant is ordered to pay the sum of 4,485,492 naira to the claimant with interest at the rate of 20% per annum from the date of this judgment until the sum is fully paid up. Costs of 500,000 naira awarded the claimant. Judgment is entered accordingly.
Thank the honorable judgment. We're most grateful, my lord.
Yes, I will end this session now.
Thank you. Thank you very much, my lord.
Thank you very much, my lord.